Thank you for attending What Other Alternatives? Thinking Beyond Drug Courts and Sentencing, part of the Understanding Drug Sentencing Symposium. Before we begin, we just have a few notes for those of you who may just be joining us. Note that Q&A and auto-generated transcription have been enabled for this event. Additionally, this event is being recorded. The recording will be made available as soon as possible after the event. Thank you again for joining us. Valena?
Good morning, everyone, or good afternoon, I should say, excuse me. And thank you for joining us for the final panel of this amazing conference. I'm Valena Beety. I am a professor of law at Arizona State University Sandra Day O'Connor College of Law. And I'm also deputy director of the Academy for Justice, which is co-hosting this event. But really, truly, the thanks goes to the Ohio State University Drug Enforcement and Policy Center, Professor Doug Berman, Yana Horganova, and Holly Griffin for organizing this amazing, tremendous conference. And I want to also give a thank you to Dean Jefferson Exum at Detroit Mercy School of Law and Professor Mark Osler at University of St. Thomas School of Law, who also lended tremendous support for organizing this conference. So for our final panel of the conference, we are honored and delighted to have primarily practitioners who have lived experience as policymakers, as prosecutors, working with the courts, and even surviving incarceration for a drug offense to share their own insights with drug courts and question where we go from here. We're now generations into drug courts. And yet, as you heard discussed in the previous panel, there continue to be problems with the effectiveness and, frankly, health-harming nature of many drug courts. So for our panel, for this final session, I want to introduce who our speakers are. The first is Professor Kerwin Kay, who is Associate Professor of Sociology, American Studies, and Feminist Gender and Sexuality Studies at Wesleyan University. He is the author of Enforcing Freedom, Drug Courts, Therapeutic Communities, and the Intimacy of the State, which was published with Columbia University Press in 2019. You should see a link to his book in the chat. And Professor Kay is going to provide a broad overview for us on drug courts. Our other speakers are District Attorney Sherry Boston. She is the District Attorney for the Stone Mountain Judicial Circuit, DeKalb County, Georgia, and has been in that role since January 2017. She was recently lauded by Atlanta Magazine as one of Metro Atlanta's 500 most influential people. Through her work with the Institute for Innovation in Prosecution and Fair and Just Prosecution Initiative, DA Boston has become an integral part of the national dialogue on criminal justice reform and innovative prosecution strategies specific to juvenile justice, reentry, and accountability initiatives. Director Michael Collins is Strategic Policy and Planning Director in the Office of the State's Attorney for Baltimore City. He is also the former Director of National Affairs for Drug Policy Alliance, where he worked with Congress on a wide variety of drug policy issues, including marijuana reform, criminal justice reform, overdose issues, and more. Mr. Collins truly has a substantial and successful background in policy reform. David Lucas is a therapist and social work educator and serves as clinical advisor at the Center for Court Innovation, where he consults nationally with judges, prosecutors, and law enforcement on overdose prevention, health equity, and person-centered practices. David specializes in the areas of addiction counseling, harm reduction, and problem-solving justice. Previously, he spent a decade in Toronto, Canada, as an addiction therapist and drug court clinical lead at the Center for Addiction and Mental Health. Kenneth Williams is a team leader and recovery coach at Prestera Center Residential Rehab Facility in West Virginia, and he is a member of the West Virginia Criminal Justice Reform Coalition. As someone formerly incarcerated for a drug offense, he is well known for his vocal advocacy and organizing for reforming drug laws in West Virginia. He was instrumental in challenging House Bill 2257 earlier this year in 2021, a bill that would have added 10 years of extended supervised release or a return to prison for minor violations of supervision by people convicted of drug offenses. Thank you all to our speakers today for joining us. This will be a Q&A session, and I'm turning first to Professor Kerwin-Kay to ask, in your opinion and research, what would a progressive and emancipatory policy around drug use look like? And can drug courts or something like them be a part of it?
Thank you very much. I think I can't turn on my video, so this is not my image, of course. That's my cute little dog. Thank you. Perfect. So thanks for everyone who put this together, folks who are visible and also folks behind the scenes. I'm very excited to be here. And for me, while some of the elements of drug courts have been very innovative and promising, overall, I feel that drug courts have been a significant failure in creating the types of reforms that we need. And ultimately, I'm thinking that we need to turn more towards decriminalization and a more robust public health response as a way of approaching drug issues. Advocates of drug courts have been very successful, I think, in targeting different audiences with different messages about what drug courts are. And that's generated a lot of bipartisan support for drug courts. So they talk about accountability for audiences, which favor sort of a more tough on crime approach. They talk about monetary savings with fiscal conservatives, and they offer the message of treatment and sort of a more humanitarian benevolence for reform-minded audiences. But these three elements don't seem to fit very well together in my mind. And they've resulted in a model of therapeutic jurisprudence, it's sometimes called, in which the therapeutic is very much the adjective, I think, while a tough-minded approach to jurisprudence remains the noun and the central focus within the courts. So what drug courts have done well, I would say, they've created a model which offers both a language of possible social inclusion, and they've combined that rhetoric with access to social services that provide some oomph to that promise. Where drug courts fail, I would say, is in making that model of social inclusion only a contingent possibility for people who fulfill the requirements of the program, rather than automatically extending that vision of inclusion and making it an immediate reality, which is much more what I think we need to do. So if there's one statistic that really highlights the way that drug courts operate in my mind, it's that 50% of people fail at drug courts and are sentenced. And that 50% is disproportionately Black, disproportionately poor. And when one fails at drug court, one typically faces sentences that are longer than if one had initially gone for a plea deal. And most courts require that one plead guilty as a condition of participation. And that's part of how drug courts save money. That's part of how they streamline the court process. That's part of the intention of drug courts. So it's not a feature that can readily be set aside in most cases. So when one fails at drug court, one receives no credit for the time they've spent under the court's control. And now one generally serves time for the most extreme sentence that the district attorney's office might have been able to bring against you initially with no opportunity to plea bargain anymore. So what the drug court does in effect is it allows the half of people who succeed at drug courts and who graduate from the program, they get a pretty good deal. They get those services, and they get the charges removed from their record or held in abeyance. But it actually intensifies the war on drugs against those populations, disproportionately Black and poor, that need relief the most. And that fact makes drug courts, at least as they're currently constituted again, a real non-starter for reform in my mind. The reason why so many people fail at drug courts is directly related to this commitment to accountability. And what accountability is taken to be, it pertains to the ways in which drug courts rely upon and even reinforce other elements that are mobilized within the criminal justice system toward the war on drugs. So people are brought into the drug court by policing practices, which are very much class targeted and racially disproportionate. The drug court relies upon the threat of a highly punitive and non-rehabilitative model of a prison system in order to get people into the program. And it uses the threat of the prison system in an ongoing way in order to motivate people and coerce people within the program itself. So part of what drug courts do, in my mind, is they take attention off of all these other aspects of criminal justice reform that are needed within the war on drugs. And in fact, it takes those elements of the war on drugs and instead positions them as therapeutic tools that are essential for the program's operation. And when you talk with drug court practitioners, they will very clearly acknowledge that they need these coercive apparatuses, or very few people would participate in their programs if they didn't have that threat to coerce them into the program. So far from reforming these aspects of the war on drugs, the drug court model involves figuring out ways to utilize and maximize the threat of the war on drugs. And drug court practitioners have been very vociferous defenders of the existing war on drugs. So for example, the National Association of Drug Court Practitioners has opposed any moves toward decriminalization of drugs, even marijuana, and even the lessening of penalties associated with drug use, because they understand that they need those coercive tools in order to bring people into the program, or people wouldn't participate. So the creation of this professional lobby, the National Association of Drug Court Practitioners, that actively opposes reform and the war on drugs, I think speaks volumes about the symbiotic relationship that the drug court model has within the overall war on drugs. And I just want to say a little bit about the role of the war on drugs. There's been a lot of sort of back and forth about what is the exact role of the war on drugs within the rise of racialized mass incarceration. And several people have pointed out that the war on drugs, has not been the key driver. It's been one of a few key drivers of this overall rise of racialized mass incarceration. But the war on drugs has played a particular part, and I'm not sure how well you'll be able to see these two charts. If I can maybe raise this, enlarge this a little. So in this first, you'll see going back for decades, this is the level of racial disproportionality in prison admissions. And you can see this is the pink line is the white level, the blue line is the black level, and this is the level of disproportionality. And you can see for many decades, there was, there's always been disproportionality in prison admissions, but that level goes up precisely as the war on drugs is really picking up, and goes up to ninefold. So historically, it was like about a 4 or 5 level of disproportionality, but that doubles effectively as the war on drugs gets going. And within this second chart, this is sort of a level of racial disproportionality in relation to different types of crime. And you can see with the war on drugs, that level of racial disproportionality increased only in relation to the war on drugs, in relation to drug crime. So what you're seeing is that this heightened increase of racial disproportionality in prison admissions is directly related to drug crime. And the ways that the war on drugs police that in a very racially disproportionate way in terms of targeting particular communities and so on. So, so even as many of these drug-related crimes are for shorter sentences than other types of crime, they've been key in terms of putting more Black and brown people into the prison system, even if they sort of are cycling through it more rapidly than with some of the other crimes. So a second issue I want to bring out with that 50% failure rate concerns the reasons for those, quote, failures. I sort of always have to think, how does one fail at drug treatment? Does not treatment fail you? But indeed, people are said to fail. But what are the reasons for that failure? And what are the reasons for the racial disproportionately that most studies find? And of course, one level pertains to individual level bias. one would never want to dismiss that as a factor. And anytime you increase the number of decisions that are being made about a given person's fate, you're allowing more possibilities for bias to creep in and have a cumulative effect that's much greater than any given single decision. So with so many decisions and evaluations being made within drug court, the court becomes a space where in which even very small amounts of bias on any given decision can add up to very large disparities overall. But even more than that, I'd also want to emphasize that the overall goal of the drug court and treatment within the drug court, which, as many practitioners have said to me, has to do with much more than getting people off of drugs, but instead is related to turning people into, quote, productive citizens or tax-paying citizens, turning people away from what often gets termed as a drugs lifestyle. And so within that, work becomes the ultimate arbiter of treatment. So within many drug courts, they require that people have a job before they're allowed to graduate. This is also a focus within within many of the treatment programs that drug courts refer people to, sort of instilling that level of a particular type of self-discipline that is required for the lower tiers of the formal labor market. So at one of the treatment centers that I studied, for example, getting people accustomed to tedious, boring jobs was actually explicitly part of the program, or having counselors yell at people and having people not sort of respond and defend themselves was explicitly part of the treatment. And if somebody responded and sort of yelled back or anything, the immediate response might be something like, "What? Your job supervisor, your boss is going to yell at you, and you're going to yell back like that? You'll be out of a job quick." So this is directly related. This type of punitive treatment is directly related to this orientation towards work. So I think it's not surprising then, with work as this arbiter of success, that groups which have more experience with the formal labor market and which are most conditioned to those forms of discipline which the formal labor market entails do better within that therapeutic model that's offered by drug courts, while groups which are most involved in street hustling and which are least connected to the formal labor market do poorly. So that's directly a class effect, and then class, of course, immediately has to do with racial disproportionality as well. So while that training for the formal labor market can be a definite benefit for some, in making participation in the formal labor market the primary criteria for success, the drug court effectively criminalizes poverty, giving people who can access work an escape hatch from prison while exacerbating its effects for those who are most destitute in need. And so unsurprisingly, that focus on work, I think, has a disproportionate impact on Black and Latino populations while implicitly favoring white populations. So for all of those reasons, I would say that drug courts, as they're currently constituted, signify a negative and perhaps even a regressive reform, and why we need to move toward a broader change emphasizing decriminalization and a broad sense of public health responses, not only including things like treatment on demand, but also things like housing for people who use drugs, which has been shown to be one of the best things that you can do for populations that are using drugs. And it's also why so many different organizations, such as the Drug Policy Alliance, National Association of Criminal Defense Lawyers, the Physicians for Human Rights, and several other groups have written policy papers that are critical of drug courts. So even having said all that, though, I think there is some question about what benefits we might take from the drug court model. And drug courts, I should say, continue to exist, for example, in Oregon, where drug use has been decriminalized effectively at this point. But the drug courts continue to exist for other types of crimes that are committed where there's some level of drug involvement. And also, I imagine possibilities with drug court models in relation to issues around driving under the influence or those types of things, where you're still going to have, even if you decriminalize drug use, you're still going to have some criminal justice system involvement. And here I think that offering services to people rather than just punishment is clearly a very good idea. But there's no reason I can see to limit those services to people going through to limit those services to people who go through the criminal justice system. And the only reason that that is really in place is because drug courts have, again, been able to make this fiscal argument that we're saving money by, compared to just imprisoning people if we offer some services. But those services, I think, should be more generally available, of course. And secondly, I think critically, I think that the key way that drug courts need to be modified, even for these leftover responses, is that people should not face greater penalties for having attempted treatment and failed by whatever criteria. So there's many reforms I think that could make drug courts better, but I think that that standard of not having people face greater penalties for having attempted treatment needs to be a real baseline if we're going to consider any aspect of the drug court model to be a positive. So, and I'll leave it there. Thank you very much.
Thank you so much for providing that overview, Professor Kay. And we do have your book in the chat for anyone who would like a more in-depth analysis of the drug courts and looking for some light reading for the weekend. So given everything that you just shared with us, and particularly the racial disparities in incarceration for drug offenses and the opposition of many drug courts to drug legalization, that leads right into our next question for Director Michael Collins, who is in a prosecutor's office. How has your decision to stop prosecuting drug possession impacted your work with drug courts?
Yeah, it's a good question. I mean, I think what I would say is, taking a step back, our office for a while had discussions about stopping the prosecution of simple drug possession. And then when COVID hit, we kind of sped up our approach and we stopped prosecuting a range of offences, one of which was drug possession, paraphernalia possession. I had gone to Seattle. I had, which is a prosecutor's office that had stopped prosecuting drug possession. I'd spent time in Philadelphia. I talked to a lot of different prosecuting offices about the impact of stopping prosecution of drug possession, but it was very much like a prospective conversation. I think what we didn't really realize was, when you stop prosecuting drug possession, it does have these impacts on other areas of your office. So we had to really make decisions about, pending cases, warrants, probation, and drug courts and the kind of diversion programs were one of these areas that were going to be impacted, because obviously a lot of people going into drug court were going there for simple possession. And so, after we, introduced our policy, we dismissed a number of pending cases. I think it was somewhere like 1,400 pending cases. We ended up quashing about 1,400 warrants, many of which were for drug possession. And so we took a lot of people out of the criminal justice system who would have otherwise been there for drug possession cases. We then ended up sort of sitting down with our partners that run the drug court program, the public defenders offices, judges, and having a conversation about, okay, now that we're not prosecuting drug possession, what does that mean for drug court? And to be quite honest, like, they had been having problems getting individuals into the drug court program in the first place. I think for some of the reasons that were previously mentioned, the program can be very strict. Some people would just rather do the jail time that comes with a drug possession charge than actually do what is usually like 2 years of probation in quite a strict program. And so we had conversations over a period of months about, and again, I come from Drug Policy Alliance and have certain feelings about drug courts similar to the previous speaker and a lot of people on this call, but operating in the world in which it is, where drug courts will continue to exist, like, is there a way of revamping drug courts to make them, a little bit more humane, lower the barriers to entry? and focus on, rather than focusing on, drug use in and of itself, focusing on, the crimes that might be associated with drug use. And so, some of the changes that we did were really aiming to, almost incentivize people to come into the drug court program. Lowering, I mean, there were barriers to entry in terms of convictions. We tried to lower that. We had been previously saying that you couldn't be convicted of an offence, a violent offence, in the last 10 years. We had an expungement process at the end of drug court, which is an attractive proposition, but at the end of the day, expungement is still a little bit of a hassle for people. And so we end up dismissing the case at the end, or entering what's called an ULPROS. We wanted to make sure that the drug court, I mean, we already had what I would say, compared to a lot of drug courts, like a more kind of progressive drug court, if that's not an oxymoron. We wanted to make sure that we were allowing, all forms of medication-assisted treatment, including methadone and Suboxone. We don't punish relapse, which is something that's been a big complaint about drug courts. And again, like we don't focus on drug crimes, but a crime that might be driven by drug use and that would otherwise get you serious time or a decent amount of time in prison. So, burglaries, thefts, offences that we are still prosecuting, rather than putting the person through the traditional criminal justice system. We wanted to give that person the option of going through drug court. So again, it was almost like a sort of revamping of drug court to make it a little bit more humane towards those individuals and focus less on drug use. But again, and I take the point that was previously made about we should have these drug court services more widely available in society. I think that's true. But also, when you have somebody who, has stolen a car, for example, and is facing jail time, the other option being, drug court, because the theft might have been driven by drug use, then, we would feel that going through the drug court program would be, a better use of that person's time. And again, we wanted to get away from this abstinence approach of drug court, where, the focus is on, getting the individual quote unquote clean or getting them off drugs or anything like that. We wanted to, our office, like, we are not public health experts. I think most of the people you'll find often at the table involved in drug courts are not public health experts. Our objective is not to necessarily reduce drug use, but reduce recidivism, reduce reoffending. That's one of the focuses. So in terms of like the metrics of success, whether or not we would graduate people from the drug court program, even if they had continued to use drugs, that's not really a metric for us of success. It's more, can that person stop the offending that they were doing before. And then the last thing I'll mention is one of the things we've tried to do, again, going back to that sort of approach where recognizing that some people are in the system already with drug use issues, we've started to look at, almost applying drug court retroactively. So going through cases of individuals who had been sentenced to jail time, who maybe, I'll give you an example. We had a guy who, he had stolen a bike from somebody's house and the judge gave him 5 years. It was clearly related to drug use, but the judge, felt that she wanted to give the 5 years. There were prior offences involved. Again, not trying to rationalise it, but perhaps that what the judge believed. But it was clear to us it was a drug use issue, and so the Public Defender's Office brought that case to our attention, and we're currently trying to get that person released from prison and sentenced to time in drug court, like accept time in drug court. Again, you know, I think similar to what I was saying before, like the option is not, you know, either drug court or freedom generally for a lot of people. And so when the option does become, you know, drug court or going into prison, you know, I think we feel you're better on this like probationary sort of drug court program. So that's an option that we are pursuing just now.
Thank you so much. We're going to turn next to District Attorney Boston. Thank you so much for joining us today. So Mr. Collins has just been talking about can drug courts expand and focus on crimes associated with drug use? Can they lower barriers to entry in drug court and expand access? But my question for you is a different concern, which is about carceral net widening with the promotion of drug courts as a solution for community treatment. And I wonder how you and your office have managed those concerns of carceral net widening.
Absolutely. And thank you for having me here today. One of the things that I did when I became district attorney was we set up a program similar to another office that I had before called our DCAP team, which stands for Diversion and Community Alternatives Programs. And this unit alone is tasked with kind of pushing forth programmatic ideas that are surrounding the social issues in our criminal justice system, whether that is drug, substance abuse disorder, whether that's mental health issues, whether that's socioeconomic issues. And so that team, as a part of it, they are staffed on all of our accountability courts, which are, as in many jurisdictions, kind of run by the judicial branch, right? We're just a partner, and they are the ones with the grants and leading this effort. So we also recognize, where perhaps judges sometimes don't, is that drug court is not a one-size-fits-all solution. And so aside from participating in accountability courts, we've also created other avenues within our office to address some of these issues outside of accountability courts. And if someone is not clinically appropriate for drug court or is unlikely to participate due to perhaps a low risk of incarceration, we extend some diversion programs that we offer. Now, I will say, for those of you not familiar with our office, we are a felony-only district attorney's office. So misdemeanor drug cases, which in Georgia are primarily would be, you know, simple possession or single-use marijuana cases are misdemeanors. So generally speaking, the cases we're seeing would be any other drug outside of marijuana, or anyone that's possessing what's considered to be an amount that is above what is deemed by the law to be sort of singular use. Although there are a lot of drugs that just possession of one pill would be a felony. So our diversion philosophy is that intervention should start with the lightest touch related to the criminal justice system, and only escalate it if it's needed. And drug court, we think, is a high intensity intervention. And it's most appropriate for perhaps those that are at high risk of relapse, but also have high needs, because drug courts can offer some of those social and physical supports for recovery, such as housing, work and career resources, community building for those that don't have family or friends to support them in place. And many of those folks or high needs are not appropriate for self-direction. So we recognize that someone in our office that is simply facing a probation sentence really has no incentive to opt into a drug court, but we don't want to wait for something bigger to happen. And so we do offer something that's not as intense as drug court. And we encourage our attorneys to think of diversion in the same way that they would think about how to prosecute a case. So if it's a case this is likely to be a probation case, we also encourage people to look at these cases and say, probation is also a form of incarceration, right? So we found that people tend to default to, oh, well, I'll just put someone on probation. And so we continue to encourage these conversations, especially around cases that we know are connected to substance abuse disorder, that they should be thinking about declining to prosecute that case. If you, in your mind, it's just enough for probation, then we want you to think, well, then I should be thinking about diversion or perhaps a declination. And we offer lots of ideas around that declination. Because again, like I said, all of our cases, these are felonies, and we're not dealing with misdemeanor marijuana possessions, because those are misdemeanor offenses in the state of Georgia. So we have to continue to have the conversation for folks to understand that probated sentences and drug court are not for everyone with substance abuse disorder, that there are some in-betweens. And I think the main issue is, I think people tend to say, well, if I don't use the criminal justice system as a hammer, then how can I help that person get the supports they need? And we have had to really reframe the conversation and say, the criminal justice space really isn't the place to use for people with substance abuse disorders. If we can divert them to programs and resources to address the underlying issue, then that's what we should be thinking about. But what we shouldn't be saying to ourselves is that we should keep a criminal case that we know is connected to drug use or substance abuse disorder, just as a way to hold on to people because we believe that we can get them better. Because we know, although we don't really like to see it or say it in the criminal justice system, something to Michael that just said, it's like this idea that someone that has a substance abuse problem is just going to be able to be abstinent. And that as long as we continue to think about it in the form of abstinence, we will never move forward, because that is, in many circumstances, perhaps in most circumstances, an unrealistic expectation over the course of someone's life. Because this isn't about 30 days, 6 months, or a year. Folks that have substance abuse disorder will have this for the rest of their lives. And I think we all know that there's an expectation that we're going to have highs and lows. And sometimes we're going to be successful, but sometimes we're going to have relapses. And that's just a normal part of a path of sobriety. And so we have to continue to have those conversations in order to fully understand how we can be a part of healing while not hurting at the same time.
Thank you. And, one issue I know has been remarked on more broadly is how informed are prosecutors' offices about substance use disorder? So I, for one, really appreciate hearing you speak to that and the challenge of demanding abstinence. So thank you. DA Boston also acknowledged the role of the judicial branch and the importance of judges. So I'd like to turn now to Mr. David Lucas. I'm going to be sharing a resource from the Center for Court Innovation in the chat. And if you're in a district other than that of DA Boston's or Mr. Collins, in some parts of the country, drug policy has been more static. And drug courts remain a go-to response. So, Mr. Lucas, what are the opportunities for reducing some of the harms of drug courts?
Thanks so much. I just want to quickly say thanks to everyone for the invitation to participate. I'm just really honored to join this esteemed panel of experts and practitioners. I also want to just quickly say that my views by no means represent the Center for Court Innovation or our funders today. In fact, I probably am more representative of a much younger me the practitioner me today. So think of me as kind of like a much younger free agent version of myself. But with that, so taken for granted in that question is like an acknowledgement that drug courts have the potential to produce harm. So instead of saying, you know, how can drug courts improve? How can they be better? The question is, how can they reduce harms? And I think that's an important framing, because I think it's important in fields, in the helping professions, in fields where the kind of the paradigm is about fixing a social or health problem, that we start from a place of looking at ourselves as system actors, as institutions, as pieces of a technocratic process that have the potential to, you know, produce harms. And I'm a social worker, so I say, you know, it's very true of the field of social work too. We have a long history of producing harm. We have a lot of good intentions. We've tried to do good things. We've also, you know, been a part of a lot of harmful moments in history as well. And I think it's important, you know, it behooves us to always be looking at our own profession and starting from a place of like, what mistakes have we made? How can we do better? So that's kind of how I work in the drug court field. I kind of work from a place of like, what's going on right now that's potentially not always being seen, and what can we look at? So we've got a lot of experts on the call today who are probably better than I at imagining kind of like a big structural solution, a brand new model to replace this one. But what I'm focused on the most lately are kind of like the micro practices, the everyday things that are happening. I'm as a clinician, I think about participants first. So I've kind of been focused on, and as the publication in the chat talks about, kind of focused on the safety of the participant. I take for granted that generally speaking, most drug court participants are not wreaking havoc on their communities. They're not actually risky, scary people. They've committed crimes. Often, as we've heard before, sometimes those crimes are simple possession, and sometimes those are things like stealing a car. But generally speaking, this is a population that once in a drug court can be treated one of two ways. They can be treated truly like a criminal, or they can be treated like somebody with a health issue. So my focus has been on thinking about, you know, first off, the culture of a drug court. How punitive and how coercive is it? You know, by definition of being part of the justice system, there's always going to be a kind of a coercive element. Somebody's coming in with a charge, and so they're kind of at the behest of the court. But what happens after that person joins a drug court? It doesn't have to be punitive. It doesn't have to be coercive. So, you know, how do we treat participants? Do we treat them? Do we use language that promotes dignity and autonomy, you know, of participants? What kind of overreach are we seeing in drug court practices in terms of saying you can use these medications, but you can't use these other ones? What about you can be in this relationship, but we don't want you to be in that relationship, which is something that we see often. And how are drug courts talking about recovery? We heard it mentioned earlier that a lot of practitioners are not experts in addiction and mental health. And, you know, are they thinking about substance use and mental health in binary ways? You're clean, you're sober, you're dirty, you're clean, you know, that type of language, and what that kind of reinforces. I also just think about kind of other everyday practices. It's been mentioned multiple times already, and that's the overemphasis on abstinence and drug testing outcomes. The use of jail as a sanction and all the harms that can promote, ranging from increasing overdose risk to treatment failure to recidivism in the long run, sanctioning substance use at all, as opposed to just responding with you know, kind of like a treatment response. The imposition of participant fees, especially given that most participants are very low income. The tendency to overtreat based on somebody's criminogenic needs. So if they're facing 2 years of jail, sometimes drug courts see that as, oh, they have to go to the most intensive treatment, as opposed to making that decision based on their actual treatment needs. Relative openness to harm reduction practices and principles really varies across the field. It was mentioned also about housing. Often housing options are very restrictive. You can't smoke, you can't use, you know, if you have a recurrence of use, you might get kicked out. So we want to try to promote things like more low barrier, harm reduction oriented housing. Then there's a bigger, broader legal and constitutional issues like who is included and excluded in drug courts, what types of compliance issues would warrant an expulsion, potentially leading to a worse legal outcome than they were facing in the first place, as it's been mentioned, what medications a court might favor over other ones. You know, I think the field's dramatically improving in this respect, but early on there was a propensity to kind of encourage the use of naltrexone over methadone and buprenorphine, because naltrexone is a non-narcotic and it's a full blocker, and the idea that anybody could be using a medication and still potentially getting high seemed to be antithetical to the drug court vision. But the field is at least at a national level, the speakers that are trying to improve practices are trying to encourage folks to use the more evidence-based medications in those cases. So credit where it's due. But what other options do we have when it comes to exploring more pre-plea options, so that folks don't feel like they're just in a program because they've got a sentence hanging over their head, and they can kind of have a larger voice in critical decision making. And then again, and I just want to reiterate this because I think it's really important, foundational questions about whether or not the drug court field, its role in reproducing certain racial and ethnic disparities, and also just kind of reifying that idea of the criminal addict. And I think this has been kind of, it was our first speaker, Mr. K, that brought this up, and I think a lot of his book is kind of centered around. Don Moore has written about this as well, and this idea of the criminal addict, and just kind of that the natural, once you're a drug user or illicit drug user, you're immediately kind of criminal. And I don't think that that's necessarily, it's fair to say that everybody in the field thinks that way, but it is prevalent. And I think there's something about trying to do treatment in the court context that just lends itself to kind of slipping into that understanding of substance use as a default, as opposed to kind of the opposite. So I think, I think I just gave you 17 questions in response to your question as opposed to answers, but I think there's lots of room in all of those spaces to change those practices. And most of what I just said is actually considered best practices in the field, which is really interesting. The technical assistance and training machine in the field is very, very busy, which to me is kind of indicative of something. So why are we so busy trying to get people to follow the model better? Why is it so hard for the field to follow the model, follow best practices? Is it something inherent in the model? Is it bad apples? Is it something about just the criminal legal system, across the country? I think when you have that much, when you're that busy trying to address less than stellar practices in the field, you need to take a step back and say, like, what's going on here? Is there anything at the core that needs to be looked at? And I think part of that is the inherent criminalization of a participant as kind of the default. I think that's where it starts. And I think that's, we have to flip that a little bit in order to see the other practices start to change. I'm a realist in this field, because I know that there's 4,000 plus drug courts in this country. They're not going anywhere anytime soon, and there's so many people in them. So my focus is, how do you make life better for those who are in the system? And I ultimately think that for practitioners, you treat participants with more compassion, autonomy, dignity, all those types of things, and your work actually gets better and easier and more rewarding too. So I kind of see it as a twofold mission. That said, as a social worker, I'm trying to work myself out of a job. As a drug court mechanic, I'm trying to work myself out of a job. Ultimately, we want upstream solutions. But I'll leave it there, because I know we have a lot of other insights. We have another speaker and other questions to get to. So thank you.
Thank you very much, Mr. Lucas. And next we will turn to Mr. Kenneth Matthews. And as a transplant from the Mountaineer State, I am so thankful you're joining us, and especially thankful of your work in West Virginia, and particularly House Bill 2257. Thank you. I know you were part of that not going through. So thank you very much. And Mr. Lucas was just talking about this inherent criminalization of participants in drug courts, and how that can be problematic. And I wonder if you could speak from your perspective as a formerly incarcerated individual for a drug offense, and as a current counselor for people in recovery, what have you seen as the impact of drug courts? And do you see a disconnect between drug laws and what you know about substance use disorder?
Well, first, thank you for having me. Really appreciate this often you recognize being formerly incarcerated and working in a field with substance use disorder. I apologize if my video or audio gets spotty. As anybody from West Virginia knows, we don't have the greatest service here, so I'll try to do my best. There's definitely a disconnect between drug courts and recovery, drug courts and substance use disorder. The issue becomes is that a lot of times in the criminal justice system, substance use disorder is considered a moral failing and not a disease, not a medical issue that somebody is going through. We in recovery liken to substance use disorder to diabetes, right? Is that you have all these precursors that make you potentially be more prone to be diabetic. So is it you morally failing that you drink a lot of soda, sweets, or eat a lot of carbs, and you become diabetic later on in life? Or is it a medical failing that you weren't maybe informed enough or didn't have access to resources to prevent you from becoming diabetic? And once somebody is diabetic, we don't look at them as, you're bad, you became diabetic because you did this, and this. But we take that same approach with those with substance use disorder and saying, you became an active user. We use stigmatizing language saying you're an addict, you're a drug abuser, you're a drug user, instead of more inclusive language like substance use, active use, person in recovery, recurrent use, those type of things that's more applicable to a medical condition. And the issue becomes, and this is an indictment of the entire drug court system, because there's some great practitioners, some great people within the drug court system that has a real heart to helping people. I see that here in the state of West Virginia. There's certain drug court justices that are really integral in getting people that they need and making it about reconnection of services and reconnecting a person to the community that they were previously a part of. But there's also a huge contingent that sees substance use as a moral failing, that the person is bad, that they deserve to be punished. And when that type of thought is used, it can't help the person with substance use disorder, because they're not only indicting themselves, but they're like, I'm being judged by everybody that says that they want to help me. They say they want to put me in this program to help me with my substance use, but they're putting restrictions on me where I can get better services. I may not be able to travel to a place where I can get a better job. And being, originally I'm from Chicago. And so transplanting to West Virginia in 2008, I came to realize one inherent truth within the criminal justice system: poor is poor. And whether you're from West Virginia in the holler somewhere and you're poor that way, or you're from an inner city in Chicago, you still receive the same barriers, because it's really an indictment on poverty, access to services in marginalized communities, whether it's here in West Virginia, Chicago, Detroit, Atlanta, Philadelphia, California. And until we get the system to really understand that, the of this substance use disorder is having connection. It's not isolating the person. It's not making them feel like they failed in a moral standard, but giving them the resources and the education necessary for them to understand that this is a medical condition that has some pre-existing factors within them that they can overcome with connection to the right resources and the right system of care. In recovery, we try to connect people with the best practices possible. I see at the facility that I work at, we have people that are court ordered to be here. Right? Now, once they get here, they're free to go if they so choose, but they know that this judge says, well, if you don't complete this program, we're going to sentence you to this 5-year term. All right. So they're going to do whatever it is that they have to do, say whatever it is they have to say to complete the program. What we try to do, as me being one of the team leads here and other staff here, is once they're here under that compulsion, try to break through those barriers and those walls that they put up because of their involvement within the criminal justice system, and let them know that there are people here that understand, that actually care about them as an individual person. We offer person-centered care, not one-size-fits-all cookie-cutter kind of thing, because you're going to miss a whole wide range of people when you try to create a model that says, well, this could work and we're going to apply it to everybody. Because every individual has different things, whether it's trauma in their background, whether it's educational history, whether it's access to resources. There's certain areas within West Virginia that has more access to resources than other areas. I currently live in Charleston. There's a huge public transit system that runs 7 days a week, pretty much almost all night. Other areas like in Boone County, Wayne County, Wyoming County, they don't have that. They don't have the transportation resources. So recognizing that there's certain barriers that is inherently available to others that's not in other individuals, and really trying to work within that model of person-centered care for them. It can be really hard sometimes, and a lot of the drug court practitioners in themselves have this stigmatizing view of substance use disorder. They have this view of, I am a justice of the court, I am a prosecutor of the court, so my job is to create boundaries and punishments. If you break outside these boundaries, you'll get punished this way. And that's not really the model that allows for somebody to have sustained recovery. The model that allows somebody to have sustained recovery is recognition that you are a human being. And as a human being, we have certain flaws, we make mistakes, we struggle with certain issues. You are no different than me, I'm no better than you. And let's come together to help you progress in a manner to attain the life that you want. There's, as being formerly incarcerated, what I found to help me post-incarceration, and I have several felony convictions for drug offenses, never once was given drug court as an option, because their standard is that a person with a possession with intent to deliver charge is a drug dealer and is not subject to drug court because they are in it for monetary gain. Even though my pre-sentence investigation report stated that I do have a substance use disorder. So recognizing the need for a wider range of offenses to be accessible to certain diversionary programs, as well as the need for that social integration. I had a lot of people help me. I had a lot of people that saw the value in me and my work before I saw it in myself. And that's what helped me progress from a person who has substance use disorder and active use to a person that's been in long-term recovery for 5 years. And being able to do the things that I do now, a lot of evidence out model of person-centered care and people saying you are valuable.
Thank you so much. And thank you also for bringing up the point about transportation. When I worked on our drug court for the Northern District of West Virginia, which is one of the only federal drug courts with Judge Alloy, it's a huge issue for rural populations, like just being able to get to treatment. So thank you for mentioning that. So we're going to do a quick round robin where everyone's going to get 2 minutes or less to answer what standard drug court practice do you feel is the most problematic or harmful? How would you fix it? And how would you get buy-in from legal actors involved? That's a lot for 2 minutes, but let's see if we can do it. And I'm going to start with Mr. Lucas.
Okay. Boy. Okay. It's hard not to pick a broader kind of core principle and because of how it affects other things. I think if I could snap my fingers, I would just immediately end the use of all jail sanctions. You know, I think there's situations where if somebody's in a drug court and they're out on the weekend and they commit a new crime and they get arrested, there's nothing that a drug court can do about that. But being put into custody for something related to drug court non-compliance, to me, unless somebody in the audience or here knows, there's no evidence base for it. We have no but we do have an evidence base to show that jail sanctions have the potential to increase overdose risk, treatment failure, and increase recidivism. So especially because typically what puts somebody in custody while they're in drug court is a low-level offense. And when we overcharge and over incarcerate low-level offenses, we increase all of the things I just listed. So that would be the one kind of micro practice that I would just do away. If I could jettison that right now, I would. But more broadly speaking, I would thinking about recovery more holistically, as Kenneth mentioned, moving away from abstinence only and just slowing down, just letting people thinking about stability first, thinking about social stability as much as health stability, shifting focus. And this is not about taking any monies and resources away from treatment, but expanding what we think of treatment to include things like housing. Like housing should be as important as treatment in my estimation. You should spend the same, if not more money on housing for a drug court. So for me, shifting away from abstinence to a more holistic understanding of recovery where there's no punishment for anybody as they move through the ups and downs of recovery, and you focus on all the other types of successes a person can have in that process. And I think from that, you would also see a lot of other practices kind of improve. Okay, I'm done.
Yeah. All right, Mr. Matthews, what do you think? What'd be the one thing you'd fix?
I'm actually going to piggyback for Mr. David Lucas. The inherent punitive nature of drug court sanctions. There's, as he said, there's no evidence-based practice that incarcerating or even sanctioning someone with incarceration, whether it's 30-day shockers, 60-day shockers, is inherently helpful. It actually does more damage due to the fact that you're removing them from a lot of the social help that they were beginning. They lose their jobs that they had initially. They have the potential to lose housing. A lot of those social programs that rely on continuous, interaction on a day-to-day basis, they could possibly use help with those. So in sanctioning someone with for any violation in the drug court with incarceration is not helpful at all. Along with housing, transportation issues, even helping people get job-related skills. You want to tell somebody to get a job because they have these fees to pay. They might be on home monitoring, electronic monitoring, which here in West Virginia, they got to pay $10 a day. So $300 or $310 a month to do it. And
wow,
you're not allowing them to be gainfully employed. So a lot of it is very difficult, hard.
Thank you, Mr. Matthews. And we're gonna be going in reverse order. So DA Boston, what about you? What would you magically change?
Exactly what David and Kenneth just said. I mean, exactly. I can't say it any better.
All right. Mr. Collins, anything that you would change that would be different?
I think the focus on drug use and sort of drug possession cases and like what would be more public health and medical problems should disappear. I mean, you end up in this situation where people who are not public health experts are making all sorts of, medical decisions. I think just one of the main complaints I hear, certainly from my time at Drug Policy Alliance, was this, what feels like an overwhelming focus on drug possession cases and bringing individuals into the criminal justice system who, had not committed any other offence other than using drugs. So again, like shifting away from treating drug use as a criminal justice issue towards treating it as a public health issue, I think that means taking those types of offences out of the purview of drug courts altogether.
Thank you. And Mr. K, Professor K.
Sorry, forgot I would have to unmute myself. Yeah, I heartily agree with what everyone has said. In particular, the end of the use of jail sanctions, I think, is critical. But I guess I would also add changing the sentencing procedures if somebody, quote, fails at drug court, such that, again, they're not punished for having tried and treatment and not succeeded according to whatever criteria is being advanced. And yeah, I guess that would be the one thing I would add. I don't know how to get buy-in on that type of thing, but.
Well, I mean, hopefully the research will help support buy-in, but I know that's just one step in it. And if we're talking about policy change or about Congress, we've had a lot of talk this week about Facebook and surveillance. So what do we think about concerns that we have these 2,500 drug court programs nationally? We have other courts that have arisen out of the drug court movement. But this is jurisdiction over health and wellness. I mean, is it really just greater surveillance of marginalized individuals? Any thoughts on that? Just opening it up.
I'm gonna talk about because someone else. So, I believe, yeah, it can be considered that. It depends on the individual drug court justice and the policies kind of thing. You see it a lot more in the federal systems. From my experience, that additional surveillance, looking at social media, things like that, than you would at the state level. I don't know too many people that say, I got sanctioned on probation or parole because I had Facebook posts while they were in state custody or under state probation or parole. See that a lot with the federal system. I think a lot of times we put too much credence on that whole indictment overseeing penalty over health issues. You don't give somebody, again, related to diabetes, you don't tell somebody who, when they go to the doctor and they get recognized as diabetes and get tested and their blood sugar is 400, then you're going to throw them in prison for eating that extra donut that morning or, doing stuff like that. So why are we so quick to throw people with outlined medical conditions such as youth disorder, which is mental health, medical diagnosis in prison? You're battling a health diagnosis with something that's not inherently helpful or able to provide those healthcare related treatments.
I think one of the challenges that we need to be careful of is just profiteering from the criminal justice system, especially private industry profiteering. And I think, drug courts can be an industry in and of itself. And, the sort of home detention, surveillance, that sort of stuff, it all costs money and somebody is making money at the end of that. We had an interesting situation in Baltimore when we stopped prosecuting drug offences where larger treatment facilities threatened to leave town. They said we're going to have to shut down. And it was because they weren't getting the criminal referrals anymore from, through the drug court program and through the traditional court system. and they were going to be losing money. My boss's response to that is, you should not have built your business model on the backs of poor Black and brown people. And the reality of the situation is there are a lot of folks out there that are willing to make money off those people, private prisons, etc. To make these reforms, you be careful that we're not sort of, exchanging one form of, surveillance for another.
Yeah, I'll just quickly add that, incarceration is kind of outside of my expertise, but, I've been in this field for a while, and you go to most drug court conferences and you'll see some, table vendors for recovery homes and for different treatment providers, but you see a lot of ankle bracelets, you see a lot of drug testing mechanisms, you see a lot of ways to do kind of like electronic check-ins on things. And I understand that that's always going to kind of be a piece of this model, love it or hate it, but it does tell us something. And that's a really obvious example. But the other less obvious example, and I'm saying this more as firsthand experience, when I was a treatment provider on behalf of a drug court, the power is seductive. I was a clinician aside from my drug court work, and then I was a clinician in the drug court context. And when you have the power of a court behind you to say, I'd really like you to do this longer term treatment because I think it's going to benefit you, it's kind of a seductive thing. I had to push back against that instinct because I had that power to say, the judge wants you to do this, even if, and so when normally in therapeutic spaces, you build buy-in and you work with the person, you negotiate and you try to come up with goals that align, right? So there's a contamination that happens. It's not just courts, it's not just bad judges and things like that. There's a lot of bad treatment out there. And sometimes being a pipeline from the justice system contaminates it even further. So there's the profit piece, but there's also like the surveillance instincts that kick in, the reporting to a court all the time, and having that additional leverage with the court behind you when it comes to kind of getting compliance out of your customers. So it's hard to avoid it, and this is not something that's encouraged at the national level by the best practice standards to do these types of things, but it happens. This is just the reality. And it's very similar in hospitals and other types of institutional settings where you see those other kinds of racial and class-based disparities kind of reproduced. You see, it's just that drug courts don't exist outside of those institutions. So but they do need to work harder because the power dynamics are just in place in this really firm way. And they're kind of hard to avoid unless you actively work against them. So I see treatment in the drug court context very, very hard to do at the highest level without without it being slightly contaminated by the power of the court. And it's just really tough. So I think that's an area that needs to be talked about a little bit more, lest we end up with kind of high surveillance treatment modalities becoming the norm.
Yeah, I think just another thing to add on to all of these good points. I do think that there's a question about bringing in the therapeutic into the courtroom, insofar as the therapeutic is really very involved in intimate parts of social life and personal life. And so I think David Lucas, I think he mentioned earlier that, judges are making decisions about what types of relationships you can get in or where you can live, or, I've seen what type of clothes you can wear, and or governing people's language and using the power of the court through a therapeutic modality to police these types of sort of mundane issues that may or may not be a good therapeutic evaluation, but I think there's a concern having the court being able and the state being able to make those types of intimate decisions and using that type of power. And that's already true to some extent with ordinary probation, but having a judge in charge of what is essentially sort of a judicially supervised probation program, I think really ups the ante and makes it much more possible to surveil, much more possible to enforce those types of evaluations, whether they're, quote, good evaluations or not. Just that power is something I think that is concerning.
Thank you. And in our last moment, Mr. Collins, I'm wondering if I could ask you briefly about the drug courts in your office that are post-incarceration for drug-related offenses, which could be robbery, et cetera. But do you have any tips for other jurisdictions, like perhaps DA Boston's, who might consider that approach?
I would never be so bold to give DA Boston advice, but I know that what we did was, we reached out to the public defender's office for cases of individuals who were sentenced, but the underlying, the motivation or the underlying condition that had led to the crime being committed was drug related. And then we approached the bench, and we're still continuing to have these discussions, but I'm pretty optimistic that we're going to be able to release and get a number of individuals released, to drug court who otherwise would have spent, 5 years or so in prison. So that's a much better outcome. It kind of springs from our office has a sentencing review unit that looks at supporting the release of individuals who have been sentenced on lengthy sentences, juvenile lifers, people who are in prisons for sort of 30 or 40 years. And those kind of individuals, we hired someone from the public defender's office to, support the release and work with defense counsel on the release. So it sort of is an offshoot of that. But yeah, it's very exciting, and it's just an interesting development. And I would see a positive use of the drug court model.
Thank you. And thank you so much for everyone on this panel. I'm going to turn it over to Professor Berman to close out our conference.
Thank you so much, Valena. Thank you to all the panelists today. Throughout the day, I just want to sort of close by feeling ever more confident when I do the parlor trick I sometimes do when I teach sentencing, which is why I tell students, you can't tell me about an issue in our society, good, bad, or indifferent, that doesn't have some connection to sentencing. And this last panel was so spectacular. And I think all the panels throughout the day were just terrific at capturing how, even as we try to drill into drug sentencing specifically through these couple days of panels, that it necessarily connects us to the rest of the world, and as it should. And so I am so grateful, and want to give one more round of thanks to not only you, Professor Beety, and Dean Jefferson Exum, and Professor Osler, the other folks who helped organize all of this. Also thanks to the Academy for Justice and all the staff there, as well as Holly Griffin and Yana Herdnova here at the Drug Enforcement and Policy Center, who have done the tech and other planning that has been so integral to making this work. I also should say thanks as well to the Charles Koch Foundation, the Menard family, and Menard Inc. for financial support to allow us to do all of this stuff. And I even want to make sure we don't forget about all the conference participants, not just these last 2 days, but going back to the workshops we had in June, and encourage everybody to have an eye out for both the federal sentencing reporter issue that's probably due out in a matter of weeks, with one set of papers from the workshops we did connected to this conference over the summer, and the Ohio State Journal of Criminal Law, which will be out in the spring with another set of papers. To me, that's a easy way to show how this dialogue is going to continue, but I know I've learned a lot and will carry forward so much from these 2 days into my own thinking and writing and research about drug sentencing and the range of issues connected to mass punishment and our criminal justice system writ large. And I'm so grateful to everybody to be a part of that. Thank you all. Have a great Friday afternoon. Take a well-deserved break, especially the folks helping with the tech. And please be sure to reach out to us and everybody involved if you want to continue a conversation with this. Thank you, attendees, for being a part of it as well. Be well.